Good afternoon and welcome to the Divorce Law Monitors webinar series. My name is Lynch Nardone and I'm joined by my partner, Tiffany Bentley. Today, we're going to talk about the role of the guardian ad litem and the ARC attorney in custody litigation. Before we start, let us introduce ourselves. I am the chair of the Divorce and Family Law Group here at Burns & Levinson. I've practiced divorce law for over 20 years and been involved in numerous litigations involving guardian ad litem and ARC attorneys. Tiffany?
Thanks, Robin. Good afternoon, everybody. As Robin said, I'm Tiffany Bentley. I am a partner at Burns & Levinson. My practice is divided approximately 50-50 between divorce and family law on the one hand and estate and trust litigation on the other hand. And as part of my divorce and family law practice, I am certified as both a guardian ad litem and ARC counsel. So I'll be able to offer some perspectives on that, both as an attorney in these cases and as the GAL or ARC counsel myself. So jumping into things, we're going to start by really focusing on guardians ad litem. So the first question is, what is a guardian ad litem? A GAL is a person who is appointed by the court when there is a dispute regarding the care, custody, or maintenance of minor children. And the purpose of the GAL is to gather facts and be able to report to the court so that the court ultimately can make a decision as to what is in the best interest of the children involved in the case. So a GAL is appointed when the parties, whether directly or through counsel, are not able to reach an agreement on what ultimately is in the best interest of the children, and where the court believes it would be helpful to have an outside investigator help gather the facts and help reach those conclusions. There are two different types of guardians ad litem. There's category F and category E. A category F guardian ad litem is an investigator and typically an attorney. The role of the category F guardian ad litem is to gather all of the facts and report on those facts to the court. And that will include, as we'll get into further here, it'll include speaking with both parties, as well as where appropriate, speaking with the children and or observing the children with the parties, reviewing outside documents and speaking to outside sources as appropriate, and then accumulating all of that information in a report for the court. A category E guardian ad litem is an evaluator, and this is a person who has a clinical background, whether it's a licensed social worker or a psychiatrist or psychologist, someone with appropriate clinical background who can not only investigate and report as to the facts, but also render clinical opinions where appropriate and make recommendations to the court in that respect. So that does also somewhat answer the next question, which is who can be a guardian ad litem? Guardian ad litems are typically attorneys, and they'll fall into category F, or they are clinicians, so it would fall into category E. Regardless of which type of a guardian ad litem you are, when you go through the application process and you become approved to be put on the lists to be a category E or category F GAL, you also have to go through training. It's escaping me right now. I believe it was 3 full days. It may have just been 2, but I think it was 3 days of training through the probate courts program, with one of those sessions dedicated to training on domestic violence and how to recognize and deal with issues of domestic violence in these types of cases. In addition to that initial training and certification, there are annual education requirements for guardians ad litem in both categories. So every year you have to go through certain approved seminars and submit certification to the court that you've done that. Robin?
Okay, thanks, Tiffany. So if a guardian ad litem has been appointed in your case, how do you prepare for that investigation? One thing is to choose materials that you will provide to the guardian ad litem. And what is provided to the guardian ad litem really depends on the issues that the GAL is investigating. What issues were raised that resulted in the appointment of a guardian ad litem, and what are you seeking to have the guardian ad litem determine in your case? As an example, if one party is seeking to remove the children from the Commonwealth of Massachusetts to live in another state, called a removal action, then that party would want to provide the guardian ad litem with documentation about the place where they are seeking to move, information about the schools, information about available housing, information about the travel time between Massachusetts and that new location, as well as information about that area where you want to move in terms of the activities that are available, cultural programs, recreation. This can include pictures of the school, pictures of the house you're going to live in. It can include websites with information about recreation, brochures. It can include maps that show the distance of this new home from the school, from the baseball field, from the airport, airline information so that the guardian ad litem would know if you're seeking to move, how long will your children be spending in travel? If they're going to take a flight, what are the flight schedules look like? What is the availability of travel for this new location? As well as information about perhaps a new job or why the parent is seeking to move out of state. What is there that is beneficial to the parent that you can provide to the guardian ad litem? Other issues that might result in the appointment of a guardian ad litem could be where the parents have struggles communicating. In that type of case, there may be emails or text messages between the parties that would be relevant for the guardian ad litem to look at, particularly if there's any disparagement going on, foul language, anything of that nature that makes it difficult to communicate. It would be important for the guardian ad litem to have that documentation. Other things that might be relevant to the guardian ad litem, depending on the circumstances of the case, could be something like school records for the children, IEP or 504 plans, if there's something particular about the needs of a child that are relevant to the investigation. It could include medical records. If there's a special need of a child or something relating to their obtaining medical treatment that would be relevant. There could be communications between other third parties that would be something the guardian ad litem would need. In all of these, someone involved in a guardian ad litem investigation really needs to be guided by, one, what the guardian ad litem is asking for in terms of materials. If a guardian ad litem is requesting materials, it doesn't benefit your case to just ignore that request and say, no, I'm not going to provide those things. And also, don't provide anything to a guardian ad litem unless you have discussed it with your attorney first, had your attorney look at it first, assess the value of this. You don't just want to send a pile of documentation to the guardian ad litem and ask them to dig through it. You would want something that was organized, perhaps tabbed, something that would be useful to the guardian ad litem and not just a box of materials here, figure out what you should do with this. It should be pointed, it should be necessary, and should be relevant to what the guardian ad litem is investigating. The next bullet on this slide here is discussions with your attorney. Your attorney should be meeting with you to discuss what will happen in the guardian ad litem investigation, how you should prepare, and where you should focus your remarks. What information should you be telling the guardian ad litem? Certainly a divorce, a custody litigation, a guardian ad litem investigation can be overwhelming, and you may tend to go off on a tangent of information that may not be relevant. So speaking with your attorney can help guide, where should I be focusing my attention? It certainly shouldn't be on simply bashing the other parent. So there can be some guidance and help from your attorney about how you can respond to questions from the guardian ad litem. And finally, hiring a consultant. There are people, some of them are clinicians, some of them are former guardian ad litems who can provide consulting services to the attorney and give guidance in the GAL process that can be helpful to the client. This is someone who is hired by the attorney to help work with the attorney and client on the GAL process. And again, having those discussions with the attorney, the consultant might be able to provide some additional information about what is helpful information to provide to the guardian ad litem and what is not, that you shouldn't burden the guardian ad litem with. Additionally, with the attorney hiring the consultant, there is an attorney-client privilege that attaches to it. If a party simply hires a consultant on their own outside, there's no attorney-client privilege that attaches to that, and those discussions could become part of the litigation at a later point. Back to you, Tiffany.
So next we are going to discuss what to expect during a guardian ad litem investigation. And we've come up with a bunch of different bullet points here that most GALs and most GAL investigations will include. I'm going to start on the right-hand side of the screen, the guardian ad litem is likely to ask you for a number of releases so that the GAL can obtain documentation directly from certain sources and certain providers without necessarily relying on the parties to produce the information or to produce the information fully and completely. So that would include potentially releases to the children's medical providers, releases to the children's schools, and potentially also releases to the parents' own treating therapists, et cetera, to the extent that the parent's mental health treatment is at issue in the case. If you are requested to sign releases from the GAL, would typically encourage you to do so. If there's any information that you do not believe should be released to the GAL for any reason, certainly discuss that with your counsel. If there is a Category E GAL appointed, that person may be empowered to do some testing himself or herself. And that would, if that's the case, that typically would be set forth in the appointment itself in terms of what the scope of the power is for the guardian ad litem. The appointment of a Category F guardian ad litem, so the attorney or investigator GAL, could also give that person the power to request psychological testing if they believe that it's appropriate, but that person wouldn't have the ability to actually conduct any of the testing because they're not appropriately qualified to do so. An important part of a GAL investigation is what's called collateral witnesses. And the appointment form, again, typically does tell the GAL how many collateral witnesses each party can provide. And when we're talking about collateral witnesses, we're talking about people who would have relevant information regarding the care and custody of the children, other than the parties themselves and the children. And so typically we see appointments where each parent is allowed to give 2 or 3 collateral witnesses for the guardian ad litem to contact. These people are very important because this is obviously the parents' own sort of reports as to what's been going on and what they believe is in the best interest of the children is going to be biased in their own favor. That's just the nature of the parents being involved in the process. But these third parties can be really helpful in terms of backing up a parent's position. These can be family members and friends, although I would typically discourage people from using their family members and friends because those people also would come with an inherent bias toward that parent. I think that the better route typically is to choose independent sources as collateral witnesses. And so that would include teachers or coaches or other individuals at the children's school. It could include the children's pediatrician's office or other providers. And what these people should be able to tell the guardian ad litem is A, how the kids are doing, what they're doing in school, what they're doing in sports, how they're doing medically, whether there are any issues, but also their observations of the role or involvement of each parent in these processes. So who's at the parent-teacher conferences, who's doing the communicating back and forth with the teachers and others at the school, who's bringing the kids to their extracurricular activities, who's bringing the kids to their medical appointments and following up on things like that. So I think that the overall takeaway in terms of collaterals is to try to use collaterals who you think will be helpful to you, but also who are not necessarily related or naturally biased towards you.
Okay, so moving on to the bullets on the left-hand column of this screen. Anyone involved in a guardian ad litem investigation should expect to be interviewed or receive written questions from the guardian ad litem. Interviews are typically at least twice. The guardian ad litem will meet with each parent, sometimes more, depending on the availability or the issues in the case. Usually it's done at the office of the guardian ad litem, though in the last year, some of those have been done by Zoom, of course. You would expect in such an interview to be asked, excuse me, about the history of the relationship with the other parent, about the issues in the case, sometimes background as far back as, you know, tell us about your childhood and how your parents raised you. Disciplining, how things are going with the child, your engagement with the other parent, and then anything relating to the issues in the case. With regard to these interviews, anyone participating in a GAL investigation should be on time, should be respectful to the guardian ad litem, and also you should be yourself, because you want the guardian ad litem to get to know you and who you are as a parent and what's important to you. I have had cases where guardian ad litems have sent a list of written questions that they want the party to type up their answers and submit those. You would expect those then almost verbatim to be sort of cut and pasted into the guardian ad litem report. So if you receive written questions, you would always want to have your counsel review it and help you with the responses, again, to make sure you're not providing a lot of extraneous information that is not relevant to what the guardian ad litem is looking for, and to make sure that you're putting in the information that is important for the guardian ad litem to know. The next is, how will the guardian ad litem get to truly know you or the other parent when they're doing 2 or 3 interviews with you of an hour or 2 in length? Remember what Tiffany said at the beginning is that GALs are trained. So they are trained to see behind the sort of the best foot forward that people tend to put in their presentation. They will ask probing questions about the issues that are raised by the other side. Often we hear that in the first interview, it's a lot of background and then tell me about the other parent. And then in the second interview comes the questions about, well, the other parent said this about you. How would you respond to that issue raised by the other parent? Or the guardian ad litem might say, I saw this in the pleadings that were filed in the case. Tell me your perspective on this issue. So they're not necessarily going to make clinical assessments of the answers that you give, but they will look at other source data and look for inconsistencies. For example, if a parent says, I've taken the child to every single medical appointment they've ever had, and the other parent never comes, I'm responsible for everything. And yet the medical records themselves show the other parent was at every appointment, and the one who said they were there only actually attended one. So they will look for inconsistencies both between the statements that you've made in writing and verbally and in court, as compared to the documents and with speaking with other parents. I've been to every single baseball game, I never missed one. And then they talk to the coach, and the coach says, I've never met the mother, I don't even know who she is. So that's how the guardian ad litem will look behind the information that they're told to make sure that those things are consistent or to find inconsistencies. Another thing to expect would be the children being interviewed. Again, before COVID, this would happen at the guardian ad litem's office. Typically, they have each parent bring the children to the office for different meetings. Sometimes they interview children together. Sometimes they interview children alone, meaning outside of the presence of their siblings. It depends on the ages of the children and on the issues in the case. The reason that GALs have each parent bring them is they can observe how the children interact with the parent and how they separate from the parent when they get to the office. It doesn't happen that the parents are in the interview with the children. Sometimes on the age of the children, they do not do an interview. If, it's a 3-year-old and they don't think this child would have the maturity to sit in the office by themselves, they won't conduct this kind of interview. We are often asked whether and how the child should be prepared for the guardian ad litem investigation. I would caution anyone going into a guardian ad litem investigation to not tell your children what to say, because inevitably the child goes into the meeting with the GAL and says, Mommy told me to tell you that Daddy is a liar. Okay, it always comes out that Mommy told me to say this or Daddy told me to say this. You want your children to be honest about what they have seen, heard, observed, and what they felt, and not to parrot what you've told them to say. Again, with the training of a GAL, they're going to pick up on a child who's using very adult language. And if that adult language matches what one of the parents is saying, they're going to notice that these words are coming from the parent, they're not coming from the child. Again, depending on the age of the child should be told that this is a person who's going to talk to you, who's going to help the parents to come up with a parenting plan or to get along better. However you want to age appropriately explain it without telling the child what to say. Of course, the child needs to understand why they're going in a room to talk to this person, and they should be told that they can be honest and they should be honest. One additional thing to expect is a home visit. Again, this should be happening again now that COVID is over. It wasn't necessarily happening in the last year, but a home visit is for the guardian ad litem to go to each parent's home and observe the children in their natural environment, if you would, if that's the right way to phrase it, to see the child interacting with the parent at home. You should typically want to have either an activity planned, do some cooking, do something so that's not just everyone plops down on the couch and stares at the guardian ad litem. They really want to watch you interact with your child. They will typically sort of sit in the corner, and it's not a time for them to interview or ask the child questions. Sometimes the child will take the guardian ad litem, come see my bedroom, look at what I have, these are my toys, that type of thing. But more often than not is designed as a way to watch the parent the child in their own setting. I have had other cases where the guardian ad litem would not go into the home if the home setting itself was not of concern or issue, and instead they would meet at, the bouncy playhouse type of thing and see the parent with the child there. We are often asked, if the GAL is coming, should I clean my house? Yes, of course, you should clean your house. You should have, don't go crazy and remove everything. You should have, the way that you normally live, but make sure that you've tidied up so that it doesn't look like a big mess when the guardian ad litem comes in. So those are my comments on the home visit.
Okay, and so once all of that process has been gone through, the interviews, the home visits, the releases, the document production, the collateral witnesses, the GAL's job is to take all of that information and put it into a written report that's filed with the court. So the GAL report is a really critical document, and it's typically very lengthy. I don't think I've ever seen one that is less than 25 pages, and they can easily be 40 pages or more. And so the format is typically pretty consistent among GALs, and this also is part of the training that we go through. It starts out with just generally describing what the appointment is, what the scope of the appointment is. It lists out the interviews that were conducted and the documents that were reviewed. And then it goes into pretty painstaking detail about the information that was gathered during the investigation. So for example, it will talk about the first interview with mom and all of the information that mom provided. And it most typically is more or less verbatim recounting of what mom said. It's not offering any opinions about the truth or lack of truth. It's just reporting what mother said, because again, it's fact driven. It's gathering the facts here at this stage. And so it'll do the same with respect to dad's interview, and with respect to the follow-up interviews. It will also include a summary of any collateral contacts, a summary of the observations of the parents with the children, as well as a summary of any relevant documents that were reviewed. Now, the GAL is not necessarily going to include a summary of each and every document, but more likely is going to pull out the facts from the documents that the GAL felt were really relevant ultimately to the custody issues in the case. So what I mean by that is the guardian ad litem is not likely to recount in the report what the results of every well child visit were, even if the GAL received those reports from the doctor's office and saw all of it, because unless the child has a particular medical condition, then the results of the yearly well child visits aren't really relevant to the outcome of the case. But the GAL may pull from those records who was at each of the appointments, just to give some feedback as to which parent or whether both parents were involved in that process. After all of the information is laid out in the GAL report, there then will typically be a page where the GAL summarizes all of the information and gives kind of overall rationales and conclusions for how he or she saw the facts as given, as provided by both parties and by the collateral. So that typically is going to be 2 or 3 pages long approximately. And most typically, at the very end of the GAL report, the guardian ad litem will give recommendations for the court to consider in terms of what the GAL believes is in the best interest of the children moving forward with respect to legal custody and decision making, as well as a parenting schedule, and sometimes where necessary, recommendations as to how the parties should be communicating with each other, whether it's through the use of an online tool or shared calendar, whether they should be limited to email communications or texts or whatever the case may be. The report, when it is finalized, is filed with the court. If there are two attorneys on the case, then the report is typically released to both of the attorneys as well without needing any further court order to that respect. And once released to the attorneys are permitted to show it to their clients, but are not permitted to give a copy of it to their clients. So the parties themselves, the parents themselves, will not receive a copy of the GAL report, either electronically or in hard copy. If the parties do not have lawyers, then the way they get to access and read the report is at the courthouse by actually going to the courthouse and reviewing the report. No one else automatically has the ability to access or read or review the GAL report. There are some occasions where there are, we may want to have the report released to a therapist or to a parenting coordinator or somebody like that. In order to be able to do that, you need to file a motion with the court and have the court make an order as to that further dissemination of the report. The report otherwise is kept separate. It's part of the divorce file, but it's automatically impounded, meaning that it's kept separate from the divorce file that's otherwise accessible to the public. It is also not accessible through any kind of online docketing, even to the attorneys on the case. Can't get it that way. Will the judge see the GAL report? Yes. It should be provided to the judge in connection with any hearing that's happening on the case, pretrial conferences, etc. And judges typically will review the GAL report very carefully and take into consideration what the GAL is telling them and what the GAL is recommending. That does not necessarily mean that the judge is going to follow the GAL's recommendations in all cases. It ultimately is up to the judge to make a determination of what's in the children's best interests. And based on the facts that are reported by the guardian ad litem, the judge may ultimately have a different opinion than the GAL as to what's in the best interests of these kids. Now, what should you do if the GAL report has findings or recommendations that are against you? I think that the first advice that I would offer is to reflect on it a bit. If the GAL is saying something about you that you don't like or that you disagree with, take a good hard look at it and look at the data that went into the GAL's recommendation and see if there may be something that you can improve upon, whether it has to do with the way that you're parenting the children, whether it has to do with the way that you are communicating with the other parent, whether it has to do with your use of alcohol or prescription drugs or anything like that. You may see things in here that you do not like and that are really hard for you to accept, but on reflection, there may be some validity to it, and you may be able to take the GAL's recommendations and make some positive changes in yourself and in your parenting style and your co-parenting relationship that ultimately is in the best interest of the children. Now, even after self-reflection, you may continue to disagree with what the GAL is saying about you and what the GAL is recommending in terms of your parenting and your children moving forward. And if that's the case, then you need to work with your lawyer to get ready to challenge the guardian ad litem's findings and recommendations. And so the ways to do that would include taking the guardian ad litem's deposition and subpoenaing the guardian ad litem's file. And that goes back to a point that Robin made at the beginning in terms of what documents are provided to the GAL and how you always want to be careful and talk to your attorney about what you're providing and how you're providing that documentation to the GAL. That's because the GAL's files are discoverable. So either party can serve a subpoena on the GAL and have them produce their entire file. So everything that the other parent gave to the GAL will be there. Any notes that the GAL took will be in there. Any drafts, anything else that sort of led ultimately to the report is up for grabs in terms of reviewing and trying to challenge things. So your attorney may see things in the notes that that you and your attorney believe reflect some bias in terms of the GAL, or some allegations that were made that perhaps the GAL didn't fully follow up on. And those are the types of issues that your attorney could challenge the GAL on in a deposition, and then ultimately also through cross-examination at trial, if you and your attorney want to convince the judge that certain factual findings or recommendations that the GAL made are actually incorrect and shouldn't be adopted by the court. Robin?
Yes. So what does a guardian ad litem investigation cost? The cost can vary widely, though generally the guardian ad litem has an hourly rate. Typically we maybe see $250, $350, $400 an hour. And the court will often set a limit on the number of hours that a guardian ad litem can spend investigating the case. A typical might be 30 hours. So 30 hours at 350 is 10,500. Whatever the hourly rate is, that's going to go into the number of hours. If the guardian ad litem feels that they cannot complete their investigation and report writing in the number of hours that the court has allotted, they must go back to the court and ask the court to grant them additional hours. Typically that will be allowed unless there's some reason that one party can set forth why the guardian ad litem should stop where they are now and not do any further investigation. So who pays for those costs? The court, when the guardian ad litem is appointed, will include in their order how the guardian ad litem fees are paid. More often than not, particularly in a divorce situation, you will see that the court orders it paid 50-50 by the parents or off the top of the marital estate. The court can reserve the right to allocate the costs between the parties in a different manner at the end of the case if they determined one party was doing something that warranted changing the fee structure so that one of them is paying for more of it. There are some state paid guardian ad litem investigations where the state will pay for it. That would be where the parties are indigent. Oftentimes there you might see the investigation done by someone who works in the probate department at the courthouse instead of a private guardian ad litem outside of the court. So then who pays for the deposition of the guardian ad litem, or if the guardian ad litem testifies at trial? Despite the fact that the court is appointing this person to act as guardian ad litem, they will often have the parties sign a contract at the start of the investigation that identifies them as the guardian ad litem and is essentially binds them to pay the guardian ad litem's fees. Within that contract, it will indicate who will pay in the event one of the parties wants to take the deposition of the guardian ad litem. Usually you'll see it is the person who is requesting the deposition must pay for the hourly rate of the guardian ad litem to prepare for the deposition and appear at the deposition. Read that contract carefully before signing to make sure it also doesn't say you're paying for the guardian ad litem to have an attorney present with them in the event of a deposition or trial. The guardian ad litem standards, which Tiffany referenced before, say that the guardian ad litem must be available for deposition or for trial. Both sides have the right to cross-examine the guardian ad litem at trial. So they do need to make themselves available, but they are entitled to be paid if you call them to testify at trial. Again, their contract is going to indicate who's going to pay for them if they need to appear at trial and what that cost will be. I once had the experience of a guardian ad litem who had a pretty hefty fee to appear in court for trial. And at the time of trial, we actually raised that with the judge to say we thought this fee, which seemed significantly larger than the number of hours the GAL would need to prepare or to participate, was excessive. And the judge did knock down that fee to a lower number. But be mindful of what it says within the guardian ad litem's contract relative to what the cost would be for trial, as that is an issue that you could bring up to the judge prior to the start of the investigation, should it be an exorbitant fee that you want to address with the judge before the investigation begins in case a different person should be appointed the guardian ad litem.
And we are going to spend some time talking about what it looks like when you call the guardian ad litem to testify at trial, if you choose to do so. But before we get there, I want to talk briefly about the other role that we promised to talk about in this webinar, and that is the role of ARC counsel, or the attorney representing the child, which is very different from the guardian ad litem, but also is a neutral individual who could be involved in the litigation and trial process. So an ARC attorney is an attorney who is represented by the court to represent the child in custody litigation. The ARC attorney is not paid. This is a pro bono services that many of us donate our time to in order to help out children in custody litigation. The way that you would obtain an attorney representing the child is to ask the court for it. So either parent can file a motion to have an attorney appointed to represent their children, or the court may decide themselves that an ARC attorney is appropriate in a case and they can issue an order making the appointment. Can you choose who the ARC attorney is? Potentially, if both parties agree that an ARC attorney is necessary, they could talk about people that they mutually know, who they know are on the ARC counsel list. And if that person is available to take the appointment, they can make the suggestion to the judge and the judge can appoint that person. I think that more typically in ARC cases, it's just the judges going down the list and having their clerks reach out for the next few people on the list as to their availability. At least that's how I've become involved in various ARC cases. I'll get an email from the court, from the judge's clerk, and it'll be me and a handful of other attorneys just asking which one of us has the availability to take on a certain case. Now, an ARC attorney is very different than a guardian ad litem. A guardian ad litem is charged with coming in and independently reviewing facts and drawing their own conclusions as to what they believe is in the best interests of the child or children involved in the case. An ARC attorney does not get to render an opinion as to what he or she believes is in the best interest of the children. The job of the ARC counsel is to represent the child, to hear what the child wants, and to advocate for what the child wants. So you're actually forming an attorney-client relationship with this child. And for that reason, we don't typically see ARC attorneys appointed for young children, because very young children are not able to have that meaningful discussion with counsel and be part of the process. But as kids are getting older, and I see it most typically with kids age 12 and up, although I've seen on occasion children as young as 8 have ARC counsel appointed. But in my practice anyway, my child clients have tended to be age 12 and up. And what happens then is I get appointed. I briefly introduce myself to the parents and to their lawyers, and I welcome them to send me whatever pleadings or other information might be relevant. But then I ask for the direct introduction to the children, and I meet with the children outside of the presence of their parents. Sometimes it's at their home, but we are alone. Our conversations and our communications are confidential. Sometimes we meet outside of the home at a Starbucks or a Dunkin' Donuts or wherever the children are going to be most comfortable talking to me. I've met at parks outside through COVID, all kinds of different places, just to create a setting where the children are open to talking to me about what's going on and what they believe should happen in terms of the parenting schedule and their relationships going forward with each parent. My job then, like I said, is not to decide what's in their best interest. It's to try to advocate for them to have the outcome that they ultimately want. Now, that's not to say that I won't challenge my child client to think of a different perspective. So if they're telling me something that I think is not a reasonable position to take, or one that's not likely to succeed in the litigation, even if I put my best foot forward in advocacy, I'll encourage them to consider other potential resolutions, just like I would counsel my divorce clients, the mother and father, to consider positions other than the position that they are advocating for, if it doesn't seem that that is a likely outcome in the case. But again, ultimately, the role of our counsel is to advocate for the child's position. It is not to make an independent determination of their best interests. There's reference on the slide to Mass Rule of Professional Conduct, Rule 1.14. That is the ethical rule that governs representing a client with diminished capacity. And in this respect, a client who's under the age of 18 by law is of diminished capacity. Someone who is under the age of majority has diminished capacity, but the ethical rules tell us that when you're representing a client like this, your obligation is to maintain as normal an attorney-client relationship with them as possible. So that means that their communications with you are confidential, and you are to hold them in confidence until and unless the child lets you know that they're okay with you disclosing certain facts or certain positions to their parents, to the attorneys, and to the court. One exception, and this applies outside of the ARC counsel appointment as well, if you receive information from your client that leads you to believe that they are at risk of substantial harm, then there is an exception to the confidentiality rules that would allow you to take reasonably necessary protective action, which could potentially include moving the court for the appointment of a guardian ad litem so that that person come in and take that role and actually make an independent determination as to best interests. So with that said, we'll talk a bit about what roles the guardian ad litem and the ARC counsel have at trial, and I'll turn it over back to Robin to get started on that.
Thanks, Tiffany. So I'm going to talk about what the GAL does at trial. So the guardian ad litem's report, which is the 20, 30, 40, 50 page report Tiffany talked about, in most cases is going to become an exhibit at the trial. You will see typically in the appointment of the guardian ad litem, it will say that the report becomes an exhibit at trial subject to cross-examination. So in that event, it is the party who is challenging the report who more often than not calls the guardian ad litem as a witness in order to challenge the contents of the report. The GAL sits on the witness stand and testifies as a witness in the litigation. It is an opportunity for person challenging the report to show the flaws in the report, to point out perhaps information that was in the GAL's file that didn't make its way into the report, to point out inconsistencies in the report or overall problems with their investigation. Did they fail to do a home visit? Did they interview one parent for 6 hours and the other one for only 1? Did they do anything that was outside the standards that they are supposed to apply? That is how a report could be attacked. On the alternative side, it would be to point out the positives and the findings of the GAL that your party, your client wants to have put forward. Here's the information in the guardian ad litem report that, of course, the judge has the report and can read it, but it's a lengthy report and there may be particular sentences, findings, recommendations that you want to draw the attention of the judge to. So it is testimony, but both sides have the opportunity to cross-examine as opposed to having to put in an affirmative case. The difference only being that both sides are able to ask the guardian ad litem leading questions, which makes it a little bit easier on both counsel to put in the information they want the judge to hear relative to the guardian ad litem's report. I'll throw it back to you, Tiffany, on what the ARC attorney does at trial.
Sure. So the ARC attorney does not take the witness stand. The ARC attorney does not provide testimony. The role of the ARC attorney at trial is to try to put forth evidence that ultimately would lead the judge to make a ruling, a judgment that is in line with what the ARC attorney's client has said that they want. So whatever it is that the children want, it's the ARC attorney's job to try to put evidence in at trial that will lead the judge to that conclusion. So the ARC attorney will be present at trial. The ARC attorney will be able to cross-examine any witness that is on the stand. That will include mother, that will include father, will include any other witness that mother and father put on. The ARC attorney also has the ability to call witnesses at trial if there are additional people that the ARC attorney believes could put forth relevant evidence that neither of the parents are calling themselves. The ARC attorney can also introduce various documentary exhibits at trial following the evidentiary standards, whether that's reports from the children's school or other providers, communications between the parties, or whatever it is. So the ARC attorney's job is to be an attorney fully taking part in the trial. What's difficult about it is that you are an attorney, you're at trial, and you're there without your client because the children are not coming into the courtroom. The children are not being put on the witness stand. They're not there sitting with you and passing you notes and sort of observing how it's all going. But by this point, you've formed a relationship with the child. You're aware of what their positions are, and you need to use other people and other evidence to try to convince the judge that that's the end result. You'll also have the ability to make the same post-trial written submissions that the other attorneys will be able to do. So you'll be able to submit a proposed judgment. You'll be able to submit a proposed rationale based on what you believe the evidence has shown for the judge to consider in ultimately rendering his or her decision. So there is a difference between how the judge considers information from the guardian ad litem and the ARC attorney at trial. The judge is considering information from the guardian ad litem, again, as a witness. And the judge is going to make credibility determinations, just like he or she would with any witness. And the judge is going to take a look at what the investigation was and whether the judge perceives any bias or any flaws in the investigation, whether they feel that the GAL got something right or got something wrong. In terms of considering information from the ARC attorney, well, the judge isn't really considering information from the ARC attorney. The judge is considering the case that the ARC attorney puts forward using information from other sources, from the witnesses and the evidence. And then ultimately, whatever the proposed judgment is that the ARC attorney submits, the judge is going to think about that, just like she thinks about the proposed judgments that the other attorneys submit, and ultimately make a decision about what part or all of the proposed judgments form her ultimate judgment in the case overall.
And I would just add that the judge is the decision maker. It is not the guardian ad litem who makes a decision relative to what the parenting plan or what steps need to be taken by a parent. The judge is a decision maker. So there is an opportunity for the judge to adopt the GAL's findings and recommendations, reject them completely and come up with something totally different, or do something in the middle, take some of them and not all of them. So that's why it is important to have counsel who is experienced at either presenting the report or challenging the GAL report if you're unable to settle your case after the guardian ad litem finishes their investigation.
And I think in that respect, it's also really important to know who your judge is and for your attorney to share with you sort of their past experience with their judge, because there are some judges who are more likely than others to adopt GAL recommendations, and there are other judges who are less likely to pay much attention to the recommendations. They'll just review the information that's presented and draw their own conclusions. And so you can never say for sure which way your judge is going to go, but based on past experience, your attorney should be able to tell you sort of what, if any, patterns they've observed based on historic appearances before that judge.
So do we have any questions in the no questions in the chat? If anyone has a question and you want to throw it in the chat, feel free, or you can reach out to either of us by phone or email as shown here on the slide. If there are no questions, our next episode is on June 16th. And at that time, the discussion will be about modification and contempt actions. So feel free to join us on that date.